March the 4th. Happy to have everybody here. We are first going to do just a little bit of committee business. We're going to do approval of minutes. I don't know if you looked at them, but are there any additions or corrections to the minutes? Not, we'll take a motion.
Thank you, Madam Chair. I move that we pass the minutes from February 2nd, 3rd, 4th, 5th, 9th, 10th, and 10th of 2026.
Do we have a second? Representative Bohai seconds. Any discussion? Okay. All those in favor of approving the amendment, say aye.
Aye.
Opposed, no. Okay, we have approved the amendments for those, what did I say? Amendments, sorry, minutes for 6 days. Thank you so much to our committee assistant for doing all that work. We appreciate that. Okay, committee, we're going to hear two bill hearings, then we're going to work the bill that I had mentioned to you. So we will just go ahead and start with our first bill, Senate Bill 481. I'll open the hearing. And we have Donica doing our brief today. Thank you so much.
Thank you, Madam Chair. Donica Short, Office of Revisor of Statutes. Short indeed. Okay. Senate Bill 481 establishes procedures in the Kansas Code of Procedure for municipal courts related to determination of an accused person's competency to stand trial. New Section 1 would be a part of the Kansas Code of Procedure for Municipal Courts, establishes procedures. Those procedures at any time after the defendant has been served with a complaint and before the satisfaction of sentence, if the municipal judge before whom the proceedings are pending finds that there is reason to believe that the defendant is incompetent to stand trial, the court may order a psychiatric or psychological examination to determine competency. Such a finding by the judge suspends all speedy trial requirements. To facilitate the examination, the court may order an examination and report be completed by an appropriate state, county, or private institution or facility, a licensed and qualified physician or psychologist, or an examiner from a list of competency evaluators and examiners used by the district court where the municipal court is located. No statement made by a defendant during an examination shall be admitted in evidence against the defendant in a criminal proceeding. The costs for such examination shall be paid from the municipal court funds or the general fund of the municipality. An examination shall be completed within 60 days of the order. Before the expiration of that 60-day period, the examiner shall certify to the court whether such defendant is competent to stand trial. If the examiner certifies that the defendant is competent, the suspended proceedings resume. If the examiner certifies that the defendant is incompetent, the court shall conduct a hearing to determine competency. The defendant shall be present at that hearing. If the court finds the defendant is incompetent to stand trial, the criminal charges against the defendant shall be dismissed without prejudice, and the city attorney may file a petition in the appropriate district court or request that the district attorney or county attorney review the case for the filing of a complaint in the district court. If the city attorney receives credible information that a defendant who was previously found to be incompetent has regained competency, the city attorney may refile the charges within the applicable statute of limitations. If the city attorney refiles, the court shall conduct a hearing to make a finding in writing regarding the current state of the defendant's competency. And those two provisions about refiling were the amendment that was made in the Senate committee. Section 2 adds two definitions to KSA 12-4113, the definitions section of the Kansas Code of Procedure for Municipal Courts. A person is incompetent to stand trial when such person is charged with a crime and because of mental illness or defect is unable to understand the nature and purpose of the proceedings against such person or make or assist in making such person's defense. That is the same definition used in the Kansas Code of Criminal Procedure. And treatment provider means any mental health center or clinic, psychiatric unit of a medical care facility, psychologist, physician, or other institution or person authorized by or licensed by law to provide either inpatient or outpatient treatment to any patient. Section 3 amends KSA 223302 of the Kansas Code of Criminal Procedure to provide that to facilitate a psychiatric or psychological examination of a defendant, and a court may rely on rely on the psychiatric or psychological examination ordered by the municipal court. SB 481 would take effect on July 1, 2026 after publication in the statute book. And I can now stand for questions.
Okay, thank you so much for that. What questions do we have? Representative Carmichael.
Thank you, Madam Chair. I appreciate the comprehensive briefing. Who pays for the examination?
So that is in new section 1. The cost for an examination shall be paid from municipal court funds or the general fund of the municipality.
Glad it wasn't a snake. It would have bit me right in front of you. Thank you.
Okay, any other questions for Donica? Okay, seeing none, thank you so much. Good job. Okay, we will now call our proponents. First, John Goodyear from the League of Kansas Municipalities. Welcome to Judiciary Committee.
Thank you, Madam Chair, members of the committee. Good afternoon. My name is John Goodyear, General Counsel for the League of Kansas Municipalities. Grateful for the opportunity to appear for the first time this afternoon, this time in support of Senate Bill 481, and grateful to the committee for hearing this bill. The need for this legislation is grounded in constitutional due process requirements. When a defendant lacks competency, they cannot constitutionally be prosecuted. And the circumstances in which an individual comes before a municipal court and their competency is in doubt is admittedly rare, but it does happen. Current law doesn't provide a clear authorization for municipal courts to order competency to be evaluated. So Senate Bill 481 provides that necessary legal framework to ensure that competency concerns are identified, that they're addressed in a way that protects defendants' rights and preserves the integrity of the judicial process. Importantly, Senate Bill 481 is not rigid. Instead, it offers meaningful flexibility that allows for cases to be resolved in a way that's tailored to the unique circumstances of the municipal court. For those that have been in municipal court, you know that they don't all look exactly the same. But it also respects that unique circumstances of the defendant that's coming before that municipal court. I will just make a quick note of the Senate amendments. Those were made at the request of the City of Overland Park. They just clarify some certain things. We think that they were good changes. We support the bill. We supported those amendments. We support the bill, and we would ask that the committee recommend it favorably for passage. And Madam Chair, I will stand for questions at the appropriate time.
Okay, I have one question, then we'll see about the committee. What is the process now? Or, what is this, what's the reason for this, I guess, is my question.
Thank you for the question, Madam Chair. And I think Judge Stoss is online, and she probably answered the question better than I can. But my understanding is currently, if a defendant comes before the court and their competency is in doubt, we can't prosecute them at that point. So you either dismiss the case and don't do anything, or you dismiss it and refer it to the county or district attorney, and they make a decision whether or not to bring it and make a competency determination. So, and Judge Stoss can correct me if I'm wrong on that, but currently we aren't left with options as to determining competency at the municipal court level. It's choice of dismissing or referring.
Okay, and yeah, that's helpful. We'll see if we have any questions for her. Okay, what other questions do you have, committee, for John? Anyone? Okay, I think you're off the hook.
Thank you, Madam Chair.
Okay, all right. We now have Brenda Stoss from the Salina Municipal, she's a Salina Municipal Court judge, going to join us by WebEx, and she's with us. Okay, can you hear us?
I can, yes. Thank you,
Great.
Madam Chair. I appreciate
We can hear and see you, so there you are. Welcome.
Okay. Thank you very much. I appreciate the opportunity to provide some support for this important bill that the committee is considering today. It kind of in answer to the question you had for Mr. Goodyear, the reason that municipal judges initiated this process that led to this bill that's before you today is because the statutes do not provide any clear procedure for a municipal court judge to follow when they have a defendant that appears to have a competency issue. So it's been a struggle for judges in dealing with these cases. The district court procedure has a very detailed process that the district court can use when there's a competency issue, but none of that specifically was authorized for a municipal court judge to do. So judges kind of had to deal with it the best they could based on their particular circumstances, the circumstances of the case, the circumstances of the defendant, as well as the circumstances of the court. So this bill originated a couple of years ago from a draft made that was put together by some municipal court judges as a way to hopefully provide some guidance. The bill did not move forward at that point, was studied and reworked into the form that you have before you today. So I believe this would be a very helpful bill for municipal court judges, setting out the clear steps, making it clear that a judge has authority to even order a competency evaluation to make sure that a defendant's rights are protected before a case is prosecuted. So I was part of the group that studied the issue and came up with the draft. Support the amendments, as Mr. Goodyear alluded to, that were proposed by the the city of Overland Park. I think those are also helpful to be included in the draft. And I would ask that the committee support the bill and move it forward for consideration by the body as a whole. And I'd be happy to answer any questions.
Okay, thank you so much. Appreciate that. Any questions, committee? I'll ask a question. So I noticed that that there was a Judicial Council Ad Hoc Advisory Committee, and that they were looking at the issues raised in SB 448 and from 2024. Was that, were you on that committee, that Judicial Council committee, or do you know anything about kind of the history about that?
Yes, that is the committee that I was a part of. The Bill 446 that you referred to, that was proposed by, I believe it was Overland Park Municipal Court judge who had worked with some other municipal court judges for a draft. There were some questions raised about that. The bill was not quite as detailed and really required the municipal court prosecutor to refer a case to the county or district attorney. It also had some issues with overlapping jurisdiction. So the league is who asked the Judicial Council to do a study because it is an important issue. So we didn't just want the issue to die, but obviously the bill needed some more work. So the Judicial Council accepted that to do the study and put together the committee to do that. And yes, I was part of that study committee.
Okay, that makes great sense. Thank you for that little bit of history. I appreciate that. Okay, committee, any other questions for our proponents? Okay, thank you so much, Judge. We appreciate you being with us.
Thank you.
Committee, we also have written proponent testimony from Michael Koss, the city attorney from the city of Overland Park, and they were the ones that suggested a few of the amendments that you see that the Senate implemented. And then we have written neutral testimony from Laura Nogren from the Kansas Judicial Council. So I'm sure she's might take a look at that. I'm sure that has to do with their report on the bill that Judge was just speaking about. So, okay, anything else on Senate Bill 481? Representative Osmond.
Thank you, Madam Chair. Quick question for the revisor. I know we kind of touched on this just a little bit, but do you know who officially brought this bill? The Senate likes to hide it and call it Committee on Judiciary, but I'd love to find out who brought the bill.
Oh,
Okay, thank you.
okay, so that was John Goodyear that answered that question for those that are online. Okay. Okay, that's helpful. Thank you. Anything else? Okay, I'll close the hearing on Senate Bill 481 and open the hearing on Senate Bill 462 and ask one of our revisers to give us okay, it's Donica again, to give us a briefing. Thank you so much.
Thank you, Madam Chair. Donica Short, again, Office of Revisor of Statutes. Senate Bill 462 prohibits certain public nuisance claims, requires special injury for certain public nuisance actions, and provides an accrual period for the statute of limitations in those actions. Section 1 creates a new section of law. Subsection A provides a non-exclusive list of actions or conditions that shall not be considered a public nuisance or form the basis of a cause of action. Subsection B provides that in a public nuisance claim, the plaintiff shall have the burden of proving by a preponderance of the evidence that the defendant's actions were the cause in fact and proximate cause of the alleged nuisance. When determining cause in fact, the court shall find the defendant's actions the cause in fact of the harm if the alleged public nuisance would not otherwise exist in the plaintiff's jurisdiction, or the plaintiff's expenditures to abate or address the nuisance would decrease by more than 25%. When determining proximate cause, the court shall find the defendant's actions the proximate cause if the harm engaged in the activity that directly caused the public nuisance and the public nuisance was a reasonably foreseeable result of the defendant's conduct, or the defendant controlled or instructed one or more third persons to engage in the activity that directly caused the public nuisance and the resulting public nuisance was a reasonably foreseeable result of such activity. Subsection C provides that a public nuisance claim by the Attorney General shall be brought by verified complaint, counterclaim, or third-party complaint that pleads each element with particularity. Subsection D states that a public nuisance claim may be brought by a private person only if such person has sustained a special injury. Such private person shall have the burden to prove by clear and convincing evidence that the defendant's actions were the cause in fact and proximate cause of the special injury. The court may only award damages in these cases in the form of compensatory damages for the special injury that is not otherwise reimbursed by a government entity. Abatement of a public nuisance by the defendant does not preclude the right of a private person to recover damages. A private person shall not bring a class action for a public nuisance claim. Subsection E provides that this section applies to all claims that are pending on or filed after July 1, 2026. If a pending public nuisance claim is brought by the Attorney General pursuant to subsection C, the Attorney General shall be substituted as plaintiff. Subsection F provides definitions used in this section, and G provides a severability clause. Section 2 amends KSA 60513, the civil statute of limitations for claims that shall be brought within 2 years. This section is amended to provide that a cause of action for public nuisance that involves a continuing or recurring condition shall be deemed to have accrued at the time the plaintiff first discovered or should have discovered the condition and the identity of the defendant. Subsequent recurrences shall not restart the period of limitation. SB 462 would take effect on July 1, 2026 after publication in the statute book. I can stand for any questions.
Thank you. I just want to clarify that your memo is the updated version of after the Senate made changes. What you are giving us, the memorandum that we have right here, reflects those changes at this.
I believe so. I did cross out the very second, I guess, clause requires the Attorney General to bring the nuisance claim. That was, the Senate committee made an amendment by basically amending and omitting most of subsection C. Does that make sense?
Mm-hmm.
Okay.
Yep.
You should have the, other than that, you should have the most updated.
Yep. Okay. Just clarifying that for everybody. Representative Lewis.
Yeah, I think I'm following on the same lines. I'm a bit confused because I'm looking, and I might not be looking at the right. It was in our materials, the Senate bill, proposed amendments from the Attorney General. And on C, my version starts off, notwithstanding any provision of law to the contrary, only the Attorney General shall have authority to file a claim regarding a public nuisance in the state. Is that in the Senate?
Could I interrupt just
Yeah.
a second? I think that is going to be in his testimony that he would like to see amendments put on that have not been put on yet.
Okay.
If that's my understanding, I think that's my understanding.
All right, then, thank you.
Yep. Any other questions for Donica? Representative Boheim.
Thank you, Madam Chair. Thank you for explaining the bill to us. This deals with civil code, correct? Not criminal?
Public, yes.
Thank you.
Okay, any other questions from the committee? Okay, thank you so much. Appreciate that. Oh, I'm so sorry. Representative Vaughn does have a question. So you get a wave big, I guess.
Thank you, Madam Chair. It was kind of at the last minute, so I appreciate you allowing my question. I'm just kind of reading through the bill. I think one thing that immediately sticks out to me is this new section 1, the use of the term non-exclusive list. So we have a list and then it says it's non-exclusive. So in practice, what does that mean? Does that mean it could be anything that would fall under a public nuisance claim. Could you help me understand that? Thank you.
Yeah, so that's exactly right. Non-exclusive list means this is not all that could be, and it shall not be considered a public nuisance. So it's kind of a negative. So this is just a list of things that are definitely not or cannot be brought as a public nuisance, if that makes sense. But it is a non-exclusive list, meaning it could constitute other things, such as actions at common law, judge-made.
Madam Chair, just a follow up to that. So then who would determine what would also be included if it wasn't exclusively listed here?
The judge.
The judge. Okay. Okay. Thank you.
Okay, thank you so much. All right, we will go ahead and have our proponent testimony welcoming Kansas Attorney General Chris Kobach. Thank you for being here. It's your microphone.
Thank you, Madam Chair and members of the committee. I think I've spent more time in this building this week than any other week in my life. You guys are working really hard and covering a lot of ground. And so happy to have the opportunity to answer any questions. This one is a bill that affects things that people may not be extremely familiar with, so I hope I can provide some helpful testimony. So there have been abuses of public nuisance doctrine in recent years, mostly within the last 10 years. You know, historically, those of us who went to law school, you think of public nuisances as the, you know, the factory that is producing smoke, that is infringing upon the right of individuals to enjoy their private property, or a brickyard or something like that. That was the public nuisance doctrine of 100 years ago. Now, public nuisance doctrine is being used to attack legal industries on the basis of asserted harms caused by their product. So there have been public nuisance cases filed against firearm manufacturers, say for perfectly functioning firearms, arguing that, you know, firearms cause a public nuisance of crime. You know, never mind the causation. Similarly, fossil fuels, that the extraction and sale of fossil fuels causes a public nuisance in the form of global climate change, et cetera. And so they're using public nuisance doctrine to basically attack whole industries for doing what is permissible under law. This bill would prohibit that from happening in Kansas. It clarifies what is not a public nuisance, all of these things that are typical of what a lawful business does: designing, manufacturing, distributing, marketing its product if it is a lawful product. It limits who may sue. Now, the Senate version, I did want to, someone asked a question about the sentence in red. Yeah, Representative Lewis did. Yeah, that's our sentence that we would like to add. The Senate clarified that only public nuisance claims in the state may be brought by the Attorney General's office. You get a real problem if you allow local municipalities to be bringing competing public nuisance claims. One locality likes plastics, another locality dislikes plastics, et cetera. So normally you would have this authority existing only in one legal office in the state. When the Senate made their amendments, by implication, you could read it as still allowing other entities to be bringing these nuisance claims. So the addition of that sentence would make that clear. The bill also, requires a special injury for private nuisance claims. Let me just jump to an example. Some of you may be familiar with this. It's the Ford County lawsuit. Ford County, which of course is where Dodge City is, started appearing as a plaintiff in lawsuits against the fossil fuels industry. They filed one lawsuit against a whole host of oil companies, alleging that plastics are not as recyclable as claimed, and therefore the fossil fuel industry should pay huge sums of money to cities and counties across the country. But the interesting thing is Ford County purports to represent not just the residents of Ford County, but all of the residents of Kansas and all of the residents of every county in the United States. And this is the problem when you have public nuisance claims being brought by smaller governmental entities. There are public nuisance claims brought all the time by government entities. So you might remember the opioids litigation. That is one brought by a variety of states, bipartisan Republican and Democrat states working together on what it was essentially a public nuisance claim. The cigarette case was not a public nuisance claim. That was a consumer protection claim, but you could have just as easily, one of the 90s, the cigarette against tobacco manufacturers, could have been brought under a public nuisance theory. Those are brought, and they are brought by consolidated action of attorneys general around the country. But when you throw in local municipalities bringing the same kinds of claims, it tends to slow things down. And that's what happened with the opioids litigation. A number of cities said, hey, we're going to file too. We'll hire our own plaintiffs' attorneys and we'll bring these similar cases. And it didn't facilitate any greater recovery. It just divided the recovery between a state's pot of money and a local government's pot of money. And it did slow things down a great deal. One final point about local governments, I imagine some people may be testifying in opposition saying, well, local governments need this power. No, they don't. If you do a search of case law from the last 25 years, which I did, and I can't say that I found every case, but I looked for cases where local governments in Kansas were filing public nuisance claims and winning. You won't find any other than the opioids litigation. And that's because nowadays, things like the noisy factory or the smokestack that's emitting all kinds of smoke and debris on a neighborhood, those are dealt with by zoning ordinance. They're dealt with by specific city ordinances like noise ordinances, and they're dealt with by the enforcement of state crimes by city law enforcement. So the need for local public nuisance cases is gone now because other things have filled it in. So that's my quick summary, and I'd be happy to stand for any questions at the right time.
Okay, I'll ask a quick question. Because we'll just go ahead and do questions now. The amendment that you were asking for, it is, even though your amendment was several pages long, it's really just that, I mean, I don't have a color copy, so that's probably the problem.
Right. So actually, yeah, mine is a color copy, and
Yeah, is it like on the
the
second
red words are
page?
just the first sentence added to
Notwithstanding.
that
Okay.
sentence, yeah.
And that's the whole thing that you were thinking of. Okay.
We've got some color copies here too.
Okay. Thank you for a color printer over at the AG's office. We don't have those here in the State House, but okay.
Yeah, and all the other changes were made by the Senate.
Okay, perfect. Okay, committee, who has questions? Representative Lewis.
Thank you, Madam Chair, and thank you for coming. Appreciate it. And I generally support the objective, as I understand it, of, making sure that we're not changing public policy with our lawsuits. I appreciate that. I do have some questions and concerns, though, about the particulars of the bill, which I just want to sort of go through with you. Section 1 lists the non-exclusive list of actions which can't be brought as a public nuisance or can't form the basis of public nuisance. And the first one says you can't bring an action if it has to do with design, manufacturing, distributing, selling, labeling, or marketing of a product sold in commerce unless the product is an illegal product. So as I read that, if the product is legal, like cigarettes or opioids, then you couldn't bring an action if it pertained to a defective design, manufacturing, distribution, or a mislabeling or marketing. Is that
Yeah,
is
that's
that right?
correct. And we looked at, so you'll see that many of these amendments to Section 1A, which you're talking about, narrow the bill, narrow the prohibition, and do allow for other claims and damages. Because the initial version of the bill that was filed went too far. And so we looked specifically with the opioid litigation in mind and said, okay, would this bill still have allowed the opioid litigation, which was tremendously successful and has brought millions of dollars to the state of Kansas. And as we read it, the amended version in the Senate would have still allowed the opioid litigation to move forward.
Okay, but if opioids were legal, right? I mean, selling them was legal. It was just that it was being abused. Then you couldn't, as I understand the first number 1 in the whole, you couldn't claim that there was the labeling or marketing problem if you're dealing, because it says unless such product is an illegal product.
Right.
See
The labeling would not have been able to been brought.
Or marketing.
But the misrepresentation of the product or the production of the product, well, the presentation of the product to the public in a way that didn't warn them about, you could say, well, that's labeling. It's an absence of a label.
Or marketing. That's also.
We felt like we'd be okay with the word marketing. We were, to get to your point, the labeling part is, many of the deceptive practices can be found in the labeling. We wouldn't mind removing labeling from this either, but the bottom line is you want to allow safe legal products to be marketed, but you don't, and you still, but you do want to be able to hold accountable an industry or a company that is marketing its products knowing that there is a danger and not warning the public of that danger.
I think we agree on that. Maybe we can just work on the language. Number 3, if I might, may I?
Go ahead. Mhm.
Please. Number 3, it says you can't bring an action for public nuisance if it's grounded in the aggregation of individual injuries and private rights, including but not limited to the private nuisance. So just how would this work with the kind of the garden variety pollution case that you mentioned, where you have a polluter and it's, let's say it's affecting 100 households? I mean, would that be prohibited?
Well, I think in that case, you would be, that gets into the distinction between public nuisance doctrine and a private nuisance doctrine. And the idea here is that you don't create a valid public nuisance case by putting together a bunch of private nuisance case. This has to be something that inherently hits a lot of people, no matter how it is distributed or sold.
So in that case, the solution under the law would be private nuisance
Yeah,
lawsuits?
those individuals could bring private nuisance lawsuits, yeah.
But could they under the bill bring them as a class action? I think there's something in here about that too, is there not?
I believe they can. There is a reference to class actions.
We're talking, I think on my second page, it talks about.
About a private individual bringing a public nuisance claim. Sometimes individuals will use a class action label as a cloak or a disguise for what is really a public nuisance claim.
And if I might, I'm sorry, I'll yield and come back if.
Okay, we'll come back. I think Representative Williams has a question.
Thank you, Madam Chair. Okay, I'm going to go along the same line as Representative Lewis. Now, when it comes to, I'm not a lawyer, can you explain the difference between public nuisance and private nuisance?
Yeah, a private nuisance would be an individual property owner right next to my property doing something that causes injury to my enjoyment of my private property. So, operating a junkyard that involves the smashing of vehicles and creates a huge amount of noise and things like that, that might be a private nuisance case. Now, as I said, nowadays, these things are handled by zoning anyway, but that would be a private nuisance case.
Okay, thank you. And then along the lines, okay, and this could be relevant or it could not be relevant when it comes to, I think it's where Representative Lewis was referencing was D on page 2, where it talks about what a private person can do with public nuisance. The case of like the Tide Pod challenge came up of, obviously the Tide Pods, kids saw the social media challenge, they ate the Tide Pod. There could be no lawsuit there that would prevent someone going after Tide because of a misuse of their project, because it's obviously not for consumption. Does that fall under this bill?
Well, an individual there could still bring a tort claim, a standard injury. I have been injured, my family, because my kids ate these Tide Pods and the company that made them didn't follow reasonable standards of care in marketing the product to my kid. So you can still bring a tort lawsuit as an individual.
Okay, but you can't can you bring a public nuisance lawsuit under this bill?
Only if you are showing a special injury. And I've been struggling with D myself because it's the concept, it's a public nuisance, but the injury is specialized. And it's hard to come up with good examples of what that would be. But it's a broadly, you have a product or something that's out there that is the problem, the source of the problem. And it is a general source to everyone, source of a problem to everyone, but there's a particular problem as it applies to me and my property. So it's a really narrow, I agree, D is very narrow. But most of the things that we think of as problems that people ought to be able to sue under, they can do anyway under, garden variety tort lawsuits or garden variety private nuisance lawsuits. The public nuisance one is that this thing is dangerous to everybody, and we need to take a sort of global or national approach to solving it.
I think through the lens of like, in your opinion, when it comes to like AI chatbots and ChatGPT, where you've seen where people have been advised mental health, provider information, then it leads to suicide or some type of harm. Under this bill, does that affect, that cause of action in any way?
So this gets to a comment made, I can't remember by whom, but ideally we want to address AI chatbots through legislation so that we can carefully lay out the standards that apply not only to one party before a court, but to everybody. And so my office has proposed a bill that's on the Senate side right now on what AI companies cannot do. And one of them is, of course, design a chatbot that obsequiously tries to, suggest certain things to the typically teenage user, like facilitating suicide or, all kinds of things that we as parents would regard as dangerous and nothing we would want a real human being telling our child, let alone a chatbot. So I think legislation is a better venue than litigation for regulating AI and a lot of these, problems that we're seeing.
Great. Thank you, Madam Chair.
Okay, other questions, Representative Carmichael?
Thank you, Madam Chair. Welcome, Mr. Attorney General. Always a pleasure to see you. Following up on what I think were Representative Lewis's questions, or it may have just been in your direct testimony, we had a discussion related to opioids. And this would appear, this would appear to define opioids as a product that is outside of what's prohibited. The reason I say that is I look at page 3 in the definitions section. It says, as used in this section. Illegal product means a product, the possession of which by the party alleged to be creating the nuisance, not the drug abuser, but the party creating the nuisance, the marketer, the manufacturer, etc., is specifically prohibited by law, including but not limited to a controlled substance as defined in KSA, etc. And since opioids are controlled substances and they are legal, then if I refer back to page 1 of section 1, it would appear to say at line 13, the design, manufacturing, distributing, selling, labeling, or marketing of a product sold in commerce unless such product is an illegal product. And I'm confused as since opioids are a legal product, will this statute impact the ability of you or anyone else to bring causes of action against opioid manufacturers, marketers, distributors?
At this point, the settlement on opioids
I understand
makes it highly
that.
unlikely.
Let me substitute some other medicine, and we don't know what the medicine will be a year and a half from now that is marketed improperly, such as clearly opioids were.
Right.
But it would just,
But
and
your
I don't
point
want to
is-
argue the point. I want to hear your.
Yeah, your point is that it's not an illegal product. The medicine, the controlled substance or medicine, whatever it is a legal product. And do we still have enough room to bring the lawsuit if the design, manufacturing, selling is proscribed? That's your question, right? Yeah. Well, we think we
Sure into
do.
the microphone for those who are watching.
What's that?
I just needed to use my microphone. People couldn't hear me outside the room. I apologize.
We had our staff who was involved in the opioids litigation look at this carefully, and they think we could still bring that type of lawsuit as amended by the Senate. Although I do think, labeling is one I personally question, and I wouldn't mind at all if this committee struck the word labeling, because I think labeling goes to a lot of the harm that can be caused from a product that's like a medicine or an opioid or something like that.
I don't want to belabor this, Madam Chair, but would it be the research that your staff has done in this regard that assures you that we are preserving these types of actions? Is that something that you could share with the committee so that I could have the benefit of their hard work and legal analyses?
It was a meeting of the staff, not a written
Not reduced
report.
to a formal legal memorandum, research memo, cases, any of those sorts of
But we can certainly, provide some analysis.
Anything you could do to help me, I would certainly appreciate. If I had any remaining time, I'd certainly yield it back to Representative Lewis because I think he's more adept at this than I am today.
I don't think that.
Did you have anything else, Representative Lewis?
Yeah,
Go ahead. I
but
mean,
I want others to have an opportunity.
well, I don't have anyone else on the list, but
All right.
I'm happy to take I think you're it.
I have-
Mhm.
Thank you. So my questions this time concern the cause and fact analysis. So you're defining cause and fact to be finding by the court that the defendant's action, let's see, when determining cause and fact for a public nuisance claim, the court shall find the defendant's actions the cause and fact of the harm if, and there are several possibilities. The first is the alleged public nuisance would not otherwise exist in the plaintiff's jurisdiction. So I understand you're trying to get to broad public harm, which is what public nuisance is about. But take this hypothetical. Let's say that you had a red light district, and you had 10 different hotels that were engaged in an illegal sex trade, and you brought a public nuisance. Could you? In other words, could a new public nuisance cause, in fact, be proven? Because as soon as you get rid of, 5 of them, there's still going to be a public nuisance. In other words, you're not going to be able to throw out all of the harm that you're trying to get rid of. And that's what it suggests, that you have to prove that you would get rid of that public nuisance if you brought the lawsuit against 5 of the hotels and won, but you wouldn't because there's going to be 5 more pop up the next week.
Okay, my understanding of A and B there is A is simply but for causation, but for the actions of the defendant, the nuisance wouldn't be there. B is that the abatement effort and presumably the defendant in a successful case would be ordered to abate, would reduce whatever injury by the plaintiff is suffering by at least 25%. So presumably, if all of those prostitution houses were removed, that would reduce. Your point is, well, maybe the nuisance would reemerge, but I think that's true in any public nuisance or any private nuisance case. There's no guarantee that once you solve it for this plaintiff against these defendants, the same case won't emerge years later.
Possibly. So on the 25%, so just following that example, let's say you bring the lawsuit, or depending upon if the locals could bring it too, they bring it. Are they going to have to prove, for instance, that the vice squad expenditures are going to drop by 25% because of this lawsuit? As you're saying here, the plaintiff's expenditures, plaintiff being the public entity, expenditures to abate or address the nuisance would decrease by more than 25%. So that suggests going forward, you would have to, somehow show that if you could get rid of, these 10 houses of ill repute, that your vice squad or there would be a public benefit of 25% expenditure reduction.
Yeah, I think that's just a different way of framing what I just said, whether the harm reduces by 25% or the expenditures necessary to address the harm drop by more than 25%. The point being that there is a substantial, the court's award of a favorable judgment to the plaintiffs would reduce the cost of the harm or the harm itself by 25%, the cost of abating the harm.
I just think that might be difficult, in some of those instances.
Okay, we do
that's
have
fine.
another question. Okay, Representative Martinez.
Thank you, Madam Chair. How would this work because I'm not completely grasping this whole idea, how would this work if a legal chemical spilled and contaminated a community's groundwater, is that something that this public nuisance covers or doesn't cover, or?
Well, that would probably be more of a class action tort claim, which we have plenty of in our court system. So you'd have all of the people who suffered by the careless actions of the company that spilled these chemicals would be able to bring a class action lawsuit against that company.
Okay. Okay, thank you.
Okay, thank you.
All right, thank you.
Any other? All right, appreciate that. This is like this is the Judiciary Committee, you can tell when we're talking about words and things like this. I appreciate it. I hope y'all all do. Okay, we now have Bo Royston from Fusion Law for Alliance for Consumer Action Fund. Welcome to House Judiciary Committee.
Good afternoon, Madam Chairman. My name is Bo Royston, and I'm here to speak on behalf of the Alliance for Consumers Action Fund, which is a organization devoted to pursuing pro-consumer policies. I just want to frame, because I think the questions today have been very perceptive, but I want to zoom out for a second. The focus of this bill is one specific tort action. And I think the potential trap, is to think that that's the only tort action, but that's actually the exact wrong way to think about it. If you look at these types of cases that are being brought by activists, public nuisance is often like count 10 or count 8. And the reason is because the law public nuisance is a tort that dates back to the 1500s. On my trip over here, I was reading the restatement, and it was a very broad tort. And the issue is that a lot of the problems that have been raised by the committee, the law has evolved to provide specific solutions for it, and it's done that primarily through the democratic process, the legislature. The concern and what this bill is targeted is when the legislature has made a specific policy decision about a product liability or about consumer fraud. And the opioids case was really a consumer fraud case where the legislature has passed a law and empowered the Attorney General to protect against consumer fraud. What happened in the opioids was these things were being marketed in a false or deceptive way, and as a result, people were getting hooked on opioids. The Consumer Fraud Act provides extremely powerful remedies for the Attorney General to police consumer fraud. But imagine a situation where activist plaintiffs want to go after something that the legislature does not want to make illegal. What do? Well, they throw in public nuisance as count 10, and they say, Your Honor, public nuisance is anything that causes an unreasonable interference with the right common to the general public. Well, at that point, there's really no standard, because how do you define that? You can't. Anything that causes an interference with the right common to the general public. The concern is then what happens is you take the legitimate lawmaking authority of this body and you transfer it to the court system. And worse, it's actually worse than that, because most of these cases are never going to actually get to a final judgment. They're never going to get to your Supreme Court where the justices can make law. Instead, they're going to settle. And so what you have is you have these allegations that survive motions to dismiss that then put enormous pressure on lawful companies to pay sums of money. So that's what we're talking about. We're talking about one specific tort. We're not talking about criminal activity. So the House's bill repute example, really that's a criminal law enforcement matter. Where public nuisance would come into play is if you had a municipality that was not doing its job, then you might have some nearby property owners bring a public nuisance against the city saying, hey, you got to enforce the laws. And we saw that happen in different cities around the country. For example, in Phoenix, this homeless encampment was allowed to get totally out of control to the point that literally a baby's body was found burned in a dumpster. And nearby owners came and said, look, Phoenix, you guys aren't enforcing the law. That's public nuisance. But the concern is that very legitimate use of that tort has been transformed to go after lawful things like the oil and gas that we all depend on to power our economy, plastic bottles that we buy at the grocery store, climate change. And as a result, you have activists and plaintiffs' attorneys subverting the legislature. And so that's what's going on here. I'm happy to answer questions, and I apologize if I spoke for too long, but that's kind of the framing.
You did great. I mean, you even have a little more time if you want.
Okay, well then let me, so I think in terms of what things are not public nuisance, just to be clear, the reason, the purpose behind that is those things are better addressed by other areas of law. Like I said, product liability, consumer fraud, criminal law, private nuisance, which is if the nearby landowner. So those are things where the idea is to not allow kind of the amorphous public nuisance. The causation, The reason for causation is not so much, obviously, smart lawyers are always going to ask the tough hypothetical. What about 6 people doing X? That's not 25%. But the concern is that with like climate change litigation, you have activists saying, well, any company that sold gas at any point in the last 100 years has contributed to climate change, so therefore it should be held liable. And that's kind of one of the ideas behind that, or any company that has sold plastic bottles, et cetera. One of the big concerns in Kansas specifically is this Ford County case. And that's a place where you had some plaintiffs' attorneys get Ford County to be a plaintiff in a class action lawsuit on behalf of every county and municipality in the country, saying that plastic bottles are a nuisance, and as a result, they should be forced to like somehow abate the nuisance of plastic bottles in the landfills around the country. I think that's an abuse of the judicial process. I think that's kind of the common sense reform that we're trying to get at here.
Okay, thank you. Committee, what questions do you have? Representative Carmichael.
Thank you, Madam Chair, and time permitting, there's 2 areas I want to ask about. You're Mr., is it Royston?
Yes, sir.
Okay, just so I understand who you are, member of the bar, if so, where from, where do you office?
Great question.
A little bit of biography.
I'm not a member of the Kansas Bar. I'm an Arizona-based attorney. I practiced consumer law in the Arizona Attorney General's office for about 7 years. Now I'm in private practice, and I'm not here as a lawyer, but rather as on behalf of this fund.
Okay, you're on behalf of the Alliance for Consumers Action Fund.
Correct.
I'm going to want to learn more about those folks. Can you tell me, are they a corporation, a C3, a C4? They have public membership list? Where are they incorporated? Where's their headquarters? So I can learn more about them.
They're a C4, I believe. I am not exactly sure where they're incorporated. Their mission is to promote consumer protection laws that benefit consumers, that put money in consumers' pockets.
You don't know where they're incorporated. Can you tell me where their principal office is so I can start my search to learn more about who you're on behalf of?
Their executive director, O.H. Skinner, is somebody that I practice law with in Arizona. He's based in Arizona, and that's my connection to them.
The second area, Madam Chair, and I appreciate your indulgence, it won't take long, but in your testimony, particularly at page 1, it repeatedly refers to something that you call the left and their ideological goals. The left will continue to find ways to circumvent legislative bodies, important steps to counteract the left's lawfare strategies. When you say the left, you're talking about Democrats, me and my colleagues? Are you talking about plaintiffs, lawyers? Are you talking about Antifa? Who is this organization called the left to whom you refer that is doing all of these terrible things?
Yeah, I would draw a very important distinction between you and your colleagues and the term the left. And the difference is that you're elected. You're here as an elected representative on behalf of your constituents. You have to pull haul and trade with the other representatives here. What we're talking about is activists who are trying to operate outside the democratic system to bring about social change and essentially to circumvent the legislature.
Can you share with me examples of who these activists are?
Yes, there's law firms that specialize. One law firm that's very prominent is called Scher Edling. They specialize in bringing these types of lawsuits. They do not, to my knowledge, necessarily disclose their funders. You know, it's that type of outside stuff. I actually don't know that, so let me retract that. But that's a law firm that does this type of stuff. And I think in that sense, kind of a movement of people trying to bring about a specific social change outside of the democratic process. And that's what the reference is to.
I didn't know courts were outside the democratic process, but thank you, Madam Chair.
Representative Williams.
Thank you, Madam Chair. Okay, so you gave some examples of bad public nuisance lawsuits. Can you give, I guess, in your opinion, good public nuisance lawsuits outside of the opioid?
Absolutely. I think one example I gave was a situation where you have a city not enforcing their criminal laws, and as a result, you get a homeless encampment like we had in Phoenix. That was creating massive problems. Public nuisance there allowed essentially nearby business owners to come and say, to get the court to tell the city, in just a declaratory judgment, you need to start enforcing the law, which the city started doing, and that cleared it up. That would be an example. There's historical examples. The Attorney General spoke about the smokestack that's nearby. That's kind of been supplanted by modern permitting and environmental law. But you can have examples that are as simple as somebody literally messes with a road. And as a result, that road becomes damaged and unusable. People who need that road to access their property can bring a public nuisance. That's kind of the classic public nuisance case. So our position is not that it should be eliminated entirely, but it's that it should be kind of put into like a common sense framework and not used to kind of pursue these novel approaches to try and change the law rather than come to the legislature.
So in the first case of the homeless encampment and local business owners coming together under this bill, would they still be able to do that?
Yes, and I think that's a key point, that's the idea of a special injury. And so that actually exists in the existing law, but this bill just makes it clear. A special injury is an injury that's different in kind, not just degree, from the general public. And so in that case, the local businesses had needles on their property, they had fist fights on their property, they were having to call the police multiple times a day, they weren't even able to run their businesses. And so that's the perfect example of a special injury. So private parties can bring private nuisance for interference with their land. They can also bring public nuisance. And usually you see those pled together as 2 counts in the same complaint, but that would be preserved. And then on the public side, the AG could bring it.
Great. Thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. So I guess I want to kind of clear something up because you're saying legal things shouldn't be considered a public nuisance like plastics and like oil and gas. And that just because they are, we now know, bad for the environment, they shouldn't be a public nuisance. But I think it's missing the point that the plastic companies knew their bottles weren't recyclable, and oil and gas companies knew that their products were contributing to climate change. They knew that these things were harming consumers and continued to provide them to consumers regardless. So I think that's where the nuisance comes in and why there should be the ability to sue these corporations. So what I'm getting is that you don't think public nuisance claims should be allowed in cases that don't align with a certain political agenda. It's not the nature of whether or not it's actually causing harm to the public, if you want to clear that up.
So yeah, I would say in that circumstance, what's the right tool? And I think that focus on deception, to me, sounds like a consumer fraud claim. And there's a lot of limits and restrictions on consumer fraud. My point is, when you use something like nuisance, which really has no standards, then you undermine the ability of the legislature to set parameters for consumer fraud. Or if there's a products liability theory, or if somebody's actually injured, and they're bringing a claim for their personal harm. The problem is you have all these specific tools for specific problems, then you have this kind of general background principle, and that can be abused. And that's why this bill is narrowly focused just on public nuisance. Your hypothetical, assuming the facts are true, would sound as a consumer fraud claim, for example, or a personal injury claim if those things led to somebody getting injured, et cetera.
Okay, committee, Representative Barrett.
Thank you, Madam Chair, and thank you for your testimony today. I certainly understand the bad cases, for example, like Glock shouldn't be, in my opinion, Glock shouldn't be responsible if someone, because they, law enforcement use that every day to protect themselves in the community members use that. So they shouldn't be responsible for what a bad actor uses that firearm for. So I definitely get this. My question would be, have other states enacted similar legislation? And when the concerns such as the cause of fact or labeling, are those addressed in other states' bills who have passed this?
We could follow. I'm sorry, I'm not sure on that fact yet, whether it's been enacted yet in any state. I know it's pending in some other states.
Sure. If you could send that, that'd be great. Thank you, Madam Chair.
Yep. Any other questions, committee? Okay, thank you so much. Appreciate it. Okay, committee, we also have written only proponents from Roger Gaboni, Eric Stafford, that we saw yesterday, Scott Keeby, Mike Carbo, and Mariah Day. And you can look at their associations. And we will now have the opponent testimony, and we will call John Goodyear back. Wasn't that convenient that we did these two bills on the same day?
No, it worked great for me, Madam Chair, so I appreciate that. Committee, my name is John Goodyear, General Counsel for the League of Kansas Municipalities. Grateful to appear again and grateful for the convenience, Madam Chair. So what this bill broadly does is that it curtails public nuisance significantly. So when we're looking at public nuisance, just an educational piece, it's a longstanding legal tool that governments have used to help fulfill that basic duty of government to protect health, safety, and welfare of its residents. Here, we're talking about when a condition or activity causes widespread public harm. So unlike a private lawsuit, a public nuisance focuses on collective harms. So when you're thinking about this, we've talked about the opioids, we've talked about tobacco litigation. The MSA, as the Attorney General stated, I don't think it was public nuisance, but it very well could have been, and part of the arguments were rooted in a public nuisance, but I think ultimately it was consumer protection. But these claims, these public nuisance claims, allow governments to recover costs of abating the nuisance and mitigating the effects on residents who would otherwise bear the costs with higher taxes, reduced services. So we oppose this bill because it significantly narrows the ability of the state and local governments to bring these actions and to address widespread harm to Kansans. I want to highlight two provisions of the bill that I find particularly troublesome that have both been highlighted by your questions. So you're asking the right questions. First, the bill contains a list of things that are not permitted, of public nuisance claims that are not permitted, things that are not going to be considered a public nuisance for that cause of action, but it explicitly states that the list is non-exclusive. Now, non-exclusive lists are not uncommon within statute. You know, you're familiar with the language, including but not limited to. But we're talking here about a right or a cause of action. So what we're saying is the limits on this cause of action are not limited. So what we're doing here is we're inviting courts to bar additional claims beyond those that are expressly limited in statute. Again, the list is non-exclusive. So rather than providing clarity or predictability, the bill signals an intent to broadly curtail public nuisance actions in a way that I can't predict and no one can predict. This is particularly concerning when we're talking about the public nuisance cause of action because, as has been stated by the proponents, this is a broad cause of action, but it's used in these circumstances. It's successful in these circumstances where we don't know what the next big harm is going to be. When we're talking about tobacco, we didn't know that tobacco was going to have the adverse effects that it had in the 1950s. We didn't know the public harm that was going to happen from opioids in the early 2000s. This bill would prohibit those claims. Second, the bill imposes an extraordinary causation standard when we're talking about the cause and fact by requiring proof either that the harm would not be present but for that individual defendant, or that abatement costs could be reduced by 25% to establish cause and fact. So that's a but-for causation. We're talking about, in law school, we're talking about basic negligence claims. When I do something to you, you can prove, because we're talking about one defendant, but for my action, you would not have been harmed. That's easy to prove. But when we're talking about large-scale, multiple defendant litigation, like opioids, like tobacco, that's going to be nearly impossible to prove. How would we prove that the harm to the state wouldn't have existed but for Purdue Pharma producing their opioid product? How would we prove that we could mitigate cost by 25% but for Purdue producing their product? Because there were several other manufacturers, there were several other distributors. We can't limit it to the one individual defendant. Requiring a precise showing that a specific defendant's conduct would reduce abatement costs by a fixed percentage ignores the reality of how public harms occur and how we address them. Looking forward, there's inevitably going to be some product, some activity that causes harm to Kansans at scale. I don't know what it's going to be. Nobody does. The proponents are correct that when specific causes of action exist, specific to a product, specific to something, those should be used and are used successfully. But where we can't predict it, and we can't, this bill puts us at a bad position. This bill places Kansas at a disadvantage when seeking recovery against these manufacturers. And for these reasons, Madam Chair, I respectfully urge the committee to oppose the bill and take no further action on it. Thank you, Madam Chair.
Okay, thank you. We will go ahead and do questions because that's what we do with the proponents. I am hoping to get at it to end on a good time. So if you all look at who the opponents are coming up, there's 3 more. So just kind of try to think of your questions for maybe one of the opponents. I want to let everyone ask the questions, but we're going to go ahead and do questions for each opponent just like we did for the proponent. So what What questions do we have for Mr. Goodyear? Representative Carmichael.
Madam Chair, I'm not trying to be difficult,
That'd be different.
but I do have one question for Mr. Goodyear and one for Ms. Jarman. Is that okay?
Yes, of course.
Mr. Goodyear, as I heard what you just described, that this non-inclusive list would allow activist, conservative, or liberal judges to just continue to make up certain causes of action that they think should be prohibited by this proposed bill? Is there anything here that gives them any guidance, or can they just pick out anything they want?
Thank you for the question, Representative, Madam Chair. And I won't speak to political ideology, but it welcomes judges to read it as expansively or narrowly as they wish. Of course, there's canons of construction, but judges aren't bound by canons of construction to determine what that list means in the limiting effect. But I'm troubled by a limitation of a right or a cause of action, including a phrase that says it is a non-exhaustive list.
Okay, what other questions do we have? Representative Osman.
Thank you very much, Madam Chair. Two quick questions. So your concern is about the non-inclusive list itself. Is the list list 3 different topics? Do you have any concerns with the list that's in the bill as it currently stands?
Thank you for the question, Representative. I do, but I wanted to focus on the bigger issues of the bill and not have 20 pages of testimony in front of you. I think we don't like the legislation in terms of cities, but I truly do think this is bad legislation for Kansans. So I do disagree with some of the things that are listed, but I focused more on the bigger issue that everything that's listed isn't the limitation. There's more limitations out there that we don't know about.
Thank you very much. One other quick question, if I can. In your experience, who does bring forth public nuisance claims across the state as you look across the state?
Sure, Representative, thank you for the question. State brings public nuisance claims. Localities bring public nuisance claims. I think it's pretty rare for an individual. Of course, I haven't studied public nuisance claims to know whether individuals have brought public nuisance claims, but it's not that frequently used in the state of Kansas. But we did have municipalities that brought claims within the opioid against opioid manufacturers and distributors. So it has been used. It is used by local governments. It is used by the state as a theory of recovery.
Okay, so states and municipalities. Thank you very much. Appreciate it.
Okay, other Representative Barrett.
Thank you, Madam Chair. Thank you for your testimony. With the exception of the opiate lawsuits, are you aware of any successful lawsuits by municipalities for this type of civil crime?
Thank you for the question, Representative. I can look into that. I'm happy to look into that for you. I thought about this in terms of tobacco and opioids because those are the most recent major public nuisance type of things. But I'm happy to look into that if you would like for me to.
That'd be great. Thank you, Madam Chair.
Okay, if you get any details on that, you could let our committee assistant know and she would disseminate the information. That'd be great.
Absolutely.
Okay, all right, seeing no other questions. Oh, I'm so sorry. Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Goodyear. I guess I was wondering, we heard from the proponents that other mechanisms exist to address these types of claims, things like fixing zoning, bringing other types of lawsuits, addressing it through the criminal justice system. I just wondered if you could maybe speak on that, and do you think that's actually enough to address the collective harm that is being caused in these situations, and the importance of this mechanism for municipalities?
Thank you for the question, Representative. I would say no. And when I was hearing the testimony, I was thinking of circumstances. Yes, zoning does prohibit like the massive factory that the traditional public nuisance that you think about, the pollution, the polluter. But I'll say that not every community is zoned, and those communities deserve protection too. And they brought up the fact that class action could be brought utilizing a private nuisance theory that only addresses the harm to the individual residents, and those funds would go to the residents. Any harms to local government that exists, let's say the polluter completely destroys the public water system. that wouldn't be addressed by a private nuisance claim. Of course, there might be other claims to do it, but a public nuisance claim would definitely encapsulate that. So I would say they are not.
Thank you for clarifying.
Okay, seeing no other questions. Thank you. All right, we now have Jan Jarman, Deputy City Attorney for the City of Wichita. Welcome to our committee.
Thank you. Thank you, Madam Chair, and thank you, committee, for having me. It's great to get out of the office. They don't let me out very often. Yesterday, the Wichita Police Department responded to a shooting. It happened in Center City in a tenement apartment style, a complex that's really not a full apartment. It's only probably a third of it has apartments. The rest of it is vacant and has no utilities to those apartments. And the shooting happened in one of those vacant apartments. That apartment, that building is known well to WPD and to code enforcement for being a problem with human trafficking, with the drug trade, with housing stolen goods, with vagrants going in and out, and with a few people who live there legitimately who need some help. We know about it. We're trying. We're prosecuting. But unfortunately, prosecutions don't always fit the bill. And that's where the City of Wichita does use public nuisance. We use it under 60-901, et cetera, and we use it to file injunctions on places like this apartment complex that houses both blight and crime. When we can't get prosecutions to work, then really this is our only option. And this bill would take all of that away from us. That's the perfect type situation. And the problem is that this bill would require proof that the defendant's direct actions caused the nuisance, or the defendant instructed a person to engage in the activity that directly caused the nuisance. It is an impossible burden. We could not file 6901s if this bill passes. It's done. How do we use it? I use it all the time as an attorney for the City of Wichita. Part of my job is I am the advisor to the police department. And when the police department has problem properties where prosecutions hasn't taken care of the problem, we'll file a nuisance. We filed it on 3 different motels on Broadway. They also were hotbeds for human trafficking. There was a lot of violent crime happening. Neighbors were begging us to do something. So we filed public nuisance. I did it. We went to court on it and they shut them down for small periods of time because the purpose isn't to shut down a business permanently. The purpose is to get them to clean it up. And they did. The public nuisance worked. One of them shut down and rebuilt part of their motel because we found out through that lawsuit it was unsafe, that the second floor balcony was about to collapse. And because we filed that nuisance, they shut it down. They repaved their driveway because it was such a mess. They cleaned all their broken windows and they fixed that balcony and they reopened it. 2 others, we closed them for shorter periods of time because they didn't have quite the problem that first motel had, but they also cleaned up. Mattresses out of the driveway. Crime decreased at all of them, but did it decrease 25% in the Broadway corridor? Probably not, because the Broadway corridor is known for crime. And if this bill passes, I can't prove the 25% decrease that's going to be required in this bill. The City of Wichita has big city problems, and we need this. We need to keep public nuisance so we can address some of the problems that the criminal law doesn't help us address. We also used it. We shut down a bar. At this bar, there were multiple homicides, multiple. It was a rough place. And we completely shut that down. It's a hairdressing, a beauty shop now. We also used it to shut down a laundromat for a short period of time. They had a casino going on in the laundromat. And because there was a casino there was a lot of crime that was happening in a laundromat. So we used public nuisance to shut it down for 30 days. We locked the door. The court allowed us to, of course. And they took out all the machines and the crime went down in the laundromat. Because who would imagine that you would have so many robberies coming out of a laundromat? Those are all just examples of how the City of Wichita uses public nuisance on a regular basis. Do we use it all the time? No, it's difficult. I would rather go the easy route and have a prosecution. I'm a criminal attorney at heart, and that's a lot faster. These civil cases take a long time. So when the criminal doesn't work, we'll turn to these and we'll use them. So we don't use them a lot. They're very difficult. You have to amass a lot of information before you take something like this to court. But so far, we haven't lost any because it works. When I hear testimony on this, I heard one of the proponents say that this public nuisance is like number 10 on their list of in the complaint. That means they don't need this bill. If it's number 10, they have at least 9 other claims that a person is going to make. But this is all I have. So if this bill passes, it takes away the one tool that we have to fight a lot of crime in the city of Wichita. And thank you for hearing me on that.
Okay, I'm going to just go ahead and ask a question. So how is it your one tool? Because operating a casino and a laundromat is illegal. You didn't have to use a public nuisance, I'm assuming.
Not on that one. You're right. That one we can prosecute. But prosecuting doesn't shut it down. And somebody could go to jail. Frankly, not very often would you go to jail for having a line of machines. We'll take them, then they put them back in. We'll take them, they'll put more back in. The one thing that closed it permanently was for the court to tell them that they couldn't have them anymore.
Okay, Representative Barrett.
Thank you, Madam Chair, and thank you for your testimony. And I'm not an attorney, so hopefully this is not a dumb question, but couldn't it still, like under civil asset forfeiture law, there are certain crimes where you can take property. So for example, hosting a place of prostitution is a crime, and that on the civil side, you could go after that property with civil asset forfeiture. Are you saying that this affects that?
No, we don't attempt to take, I don't think on so on these prostitution cases, the hotel doesn't participate in the human trafficking, they just host it. They know it's there, they turn a blind eye and they allow it. I can't imagine how we could take it in a civil forfeiture.
Hosting a place of prostitution, though, if you look at the crimes that can be included for forfeiture is one of those crimes. Same thing with human trafficking, same thing. So that's what was my question is, like even an illicit massage business, then you can prove that owner knew, they've been warned before, maybe from letters from the Attorney General's office or from a DA's office saying illegal activity is happening here, then they do know there's that knowledge, which is usually how the process works. So that's why my question is that you could still forfeit it, correct?
I'm sure you could through the DA's office, but you'd have to get the DA on board. It would take it would take a heavy prosecution. And keeping it in the city, it allows the city of Wichita to have some control over that, even if the DA doesn't want to take that case. It would allow, keeping the public nuisance would allow the city of Wichita to have some control in what goes on in the city. So I think it's a better option.
Thank you, Madam Chair.
Representative Bohai.
Thank you very much, Madam Chair. Thanks so much for coming in today. My question is, does this bill take away the city's right to code enforcement?
That's a great question. We've talked about that. We also have an ordinance in the city called chronic nuisance. I don't think it would. We could still have code enforcement. It would weigh heavier on our chronic nuisance ordinance, although I don't think it even takes that away.
Thank you.
But none of that code enforcement answers what happens in these crime-ridden buildings. We can't lock them.
Representative Carmichael.
Thank you, Madam Chair. Ms. Jarman, I know this must be important for you to come all the way from Wichita because I know where your office is and you stay there and work hard a lot. When I got home last night, the lead story, I was watching the Wichita News, even ahead of the bond sales tax issue, was the event you just described on North Broadway. That apartment, or whatever you want to call it, lies right on the border of Representative Martinez and my district. I think it might be on my side of the border. I drove by what was once a prominent hotel on my way to Topeka as I was going down Kellogg Street. I saw another property that you all have managed to close, combination of nuisance and code enforcement. The bar that you refer to, I know exactly where it's at because I like to go to Old Town, but I didn't like to go to that part of Old Town because bullets were flying out the window. So my question is, you can't as I understand it, you can't really necessarily take municipal code criminal action against the owner of the apartment complex. He's not running the house of prostitution. He's not dealing the drugs. He's just providing the building. And can you explain to me how it is that this proposed law would keep you from closing down as a public nuisance the apartment complex, the formerly beautiful hotel that's now a terrible place, the bar where the bullets fly out so I couldn't go to Old Town and one of my favorite cigar bars across the street?
You're right, thank you. There are no laws that allow you to just shut down a business if you can't prove that they are criminally, if you can't prove that they are actively involved. But that's what public nuisance is for. When they host something, when they allow something to happen by turning a blind eye, that's where we can swoop in and say, you're dangerous to the public because of how you're running your business or how you're running your apartment. And the reason this bill would kill that is a number of reasons, which you all have actually pointed out in your questions. But the damages that the defendant's direct action is what has to cause it in order to be allowed to use public nuisance, which is exactly opposite of what public nuisance is meant for. I'll also mention that part of this bill also kills the private citizen's right to use public nuisance. And we have another house, we have a house in the city of Wichita. Bullets, it used to be a really sweet neighborhood. And bullets were flying and on a nightly basis, and they were drive-bys, and the person who lived there would not cooperate with police. He was running a used car lot out of his front lawn. And we actually now have a group out of Texas, ACT, you might have seen it in my written testimony. They're a Christian-based organization who wants to come to Wichita to empower citizens of Wichita to sue on public nuisance to get these drug houses shut down. It's very successful in the state of Texas. We'd be welcome to have them in Wichita, but not if this passes. It's done. They won't come.
Committee, any other questions? It's interesting that you mentioned ACT because I'm quite familiar with them. I've visited their headquarters in Dallas and I've driven in their neighborhoods that they've helped to clean up. I mean, they can still do private nuisance.
No.
They cannot because it's the neighbors.
Right. This bill limits what neighbors can sue for, though, and it'll limit what they have to prove in order to call it a public nuisance. So they can sue, they won't be successful. With the standards that they've put in this bill, you will not be successful. You won't win.
Okay, I just will definitely want to look into that and talk to them about that too, since I'm familiar. Okay, any other questions?
Madam.
Oh, sorry, Representative Lewis.
Thank you, Madam Chair. Can I follow up on your question?
Please.
So with respect to the private nuisance, when you say this bill would prevent that, does that have to do with the special injury element? I mean, I understand that already exists in the law, does it not?
The special relationship, yes. No, to me, it's not a private nuisance. It's private citizens suing for a public nuisance. It's what an HOA might do, for example. In this case, it would be citizens suing someone not right next door to them, but someone down the street from them, because when they drive in their neighborhood, there's a used car lot or bullets flying. And the proof of how much of a nexus between it's the requirement to prove the damages is not the special relationship part, it's the damage part that I think they cannot ever prove.
All right, thank you.
Okay, committee, any other questions? All right, we have, yes, did you have a question? Okay. Representative Vaughn.
Thank you, Madam Chair. So I was reading through your testimony, and the other thing you mentioned is that guardrails are already in place to stop frivolous lawsuits, which is what the proponents say they're attempting to address with this bill. So just kind of for the committee's knowledge, would you mind sharing a little bit of what those guardrails are?
Thank you. First of all, Ford County, this is all based, from my understanding, on something that happened in Ford County where they're suing Exxon and Chevron. They have some pretty good attorneys. And I'm pretty sure that they can take care of this case if it's frivolous. If it's frivolous, and if the court, it'll be dismissed right away. I mean, this won't go far at all. If it's frivolous, and if they defy orders of the court, they could be subjected to penalty. But mainly, it's to stop what cities do and to stop citizens' rights to sue for problems in their neighborhood so we can protect big corporations just doesn't make sense. We should be looking, to me, we should be looking to help the citizen here. And the courts will do that. The courts will protect Chevron. But we got to protect the citizen and let them sue if there's a problem in their neighborhood.
I agree. Thank you. Thank you, Madam Chair.
Okay, thank you. Yep, we'll move on to Michael Koss, the City Attorney of Overland Park. Welcome to our committee.
Thank you, Madam Chair, and thank you, members of the committee. I'll try and be quick. There have really only been two major lawsuits in Kansas that have brought this public nuisance theory, with the exception of those limited actions that Wichita mentioned. But those two limited instances have brought significant benefits to the state. The first was the tobacco litigation settlement in 1998. There were a handful of attorneys general that brought public nuisance theories. That resulted in $1.5 billion to the state of Kansas that has been used to fund children's programs. The second was the opioid settlement in 2021 that resulted in $340 million. And that litigation included thousands of municipalities across the country as plaintiffs, including Overland Park. Senate Bill 462 would make it much more difficult for Kansas to receive their fair share of damages and settlement funds from companies that cause harm, like the tobacco and opioid manufacturers involved in these past public nuisance lawsuits. It does this by limiting the actions that constitute public nuisances, makes it harder to prove causation, narrows permissible damage, and creates a more restrictive statute of limitations. Had this legislation been in effect prior to the tobacco and opioid settlements, Kansas would have stood alone as the only state that deprived its own residents of the full benefits of these settlements. And Representative Barrett, to your question, the only state that I could find in the country that has something even close to this legislation is Ohio. Within their product liability statute, there is a limited preemption of bringing those product liability claims as a public nuisance lawsuit. So I think we would be the first. And there will be nationwide public nuisance lawsuits in the future, where out-of-state companies create legal products that kill or harm Kansans. If this bill passes, it's entirely possible those companies are going to look at their liability and they're going to say, so we're paying hundreds of millions of dollars to Missouri, we're paying hundreds of millions of dollars to Nebraska. How are we only paying a fraction of that to Kansas? And the answer is, if this bill were to pass, is that in 2026, someone convinced the legislature to tie its own hands and prevent Kansas from receiving the same benefit of these public nuisance claims that other states' residents receive. I hope that's not the future, and therefore I would ask that you prevent that from happening by rejecting Senate Bill 462. Thank you.
Okay, committee, what questions do you have? Representative Martinez.
Thank you, and I hope this isn't like way out there, but with the current administration's deregulation on climate change and things like that, would more of these public nuisance claims come about? Does that make sense?
I think I know what you're asking. Is it possible that plaintiffs like Ford County could bring more of these suits? And I can't speak to that. I know that's not something that the city of Overland Park or any cities near us have expressed much interest in.
Because of the impact on oil and gas and things like that.
I couldn't speculate as to whether they're.
Thanks.
Yeah.
Okay, any other questions? Okay, seeing none, thank you. Our next proponent is Aaron Mays. I know he had to be in the tax committee. I don't think he came in. Is that right? I didn't see him come in. Okay. So he will be written only, so make sure you take a look at that. Okay, committee, seeing no other conferees on Senate Bill 462. Anything else? Any other questions? I'll close the hearing on Senate Bill 462. We could go ahead and work Senate Bill 358, but I'm okay pushing it till tomorrow if people have amendments. I don't know if you're willing to tell me if you have an amendment on that or not. You do have an amendment? Okay.
My amendment is fairly substantial. It's not just
Okay.
get us to conference amendment.
Okay,
I'll
then
be
I-
glad to share it with you after,
Okay,
so you know
but-
what I'm talking about.
So I'm hoping we can get out at a good time. So
I
are
think
you
it's going
okay
to
if-
take a little while to get it
Okay,
done.
then we will either push it to tomorrow or possibly to Monday, one way or the other, if that's okay with you, even though you're planning. All right, very good. Okay, so committee, just plan on that. We will be trying to work bills as we go along. I don't know that we'll have time tomorrow. It kind of depends on how many people we end up having that want to participate in our informational briefing for tomorrow. But we do have 2 judges coming, and then we have KLRD that'll give us some information and some other citizens across the state. And I think it'll be interesting. We'll learn a lot. So plan on that tomorrow, and then I think that's it. We won't meet on Friday, and we're adjourned.